Hand. Stand up, please. Sorry. A lot of these. Go ahead.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
All right. Now you can have a seat. Mr. Odell, you may ask.
Ms. Hester, could you please state your full name?
We're going to ask you to speak up. This is a courtroom that the sound is not very good, so I need you to speak loudly enough for anyone in the back of the courtroom to hear you, okay?
Me, Dawn Hassard.
Move up a little bit to the scooter chair up there so you can speak into that microphone. There you go.
Ms. Hester, were you previously married to Ryan Lancaster?
Yes, I was.
Okay. And were you divorced by entry of the final decree entered on January 10th, 2024?
Yes, sir.
Okay. And you and Mr. Lancaster have 2 children, is that correct?
Yes.
Okay. The final decree of divorce incorporated a parenting plan that gave Mr. Lancaster certain parenting time with the children, correct?
Yes.
Okay. And what are the names of your children?
Christian Hassard and William Lancaster.
Okay. And how old are they?
My youngest is 6 and my oldest is 11.
Okay. After entry of that final decree that incorporated the parenting plan, did something happen that caused you to file a petition for emergency restraining order and to modify that parenting plan?
Yes.
Okay. And can you tell the court what that was?
He had the children with him in a motel and got extremely intoxicated. He passed out in the pool, and my kids they did not know how to swim. And my oldest had reached out to the motel staff because he had choked him in the motel room. And he was trying to get a hold of me. And Mr. Lancaster would not let him get hold of me. He knew why, and that is why he proceeded to choke my son on the motel room.
Which child was that?
Christian Hassard.
And tell the court what happened after you received that phone call.
After I received that phone call, they said that they had to involve the police and call DCS there and make a report for child abuse and child endangerment and assault of a minor because he put both of their lives at risk and in danger. He was court ordered not to drink with the children, and he proceeded to do so anytime they were with him. And
were there other instances where he was drinking excessively?
yes, and they said that the evidence submitted to DCS was that there was a gallon of rum in the room with them.
And you were not aware when you dropped the children off that he had any alcohol with him?
No.
Okay, did you look?
Yes, I looked, and my oldest son told me that he had hid it in the bathroom. And almost as soon as I left, he proceeded to drink and denied my child to contact me.
Was Mr. Lancaster charged with aggravated child abuse resulting from that incident?
Yes.
Now, Ms. Hassard, are you employed?
Yes.
And you and the children live in McEwen, is that correct?
In Waverly.
Okay. Ms. Hassard, we've attached a proposed parenting plan to the petition, and you've seen that, correct?
Yes.
Okay. And what are you asking the court to enter in the way of a parenting plan moving forward?
I want for him not to be able to be around the children, zero visitation whatsoever, because he has constantly become intoxicated with them despite court orders several different times, and he is a danger and a threat to their lives.
You asking the court to make give you discretion to make all major decisions?
Yes.
And is your gross monthly income $4,246?
Yes.
Are you asking the court to impute his income at $3,000 per month?
Yes.
And the children are currently on teen care, is that correct?
I'm having to get it renewed as of right now. They have no coverage. I'm waiting for the approval.
And Ms. Hester, during the entirety of the children's lives, have you been the primary caregiver for them?
Yes, I've been the only one that's stayed and worked the entire time.
Just describe briefly your relationship with the children.
I have a close relationship with them. I help them with their schoolwork. I play with them. We have no activities on my weekends off. We go to the bar, do other things.
Thank you, Judge. That's all mine. That's perfect.
Well, Mr. Hassett, I'm going to give you a chance to testify yourself, but right now it's their opportunity to put on their proof. Let me make sure I'm understanding correctly that not only did he fall asleep at the pool, but then you're alleging that the allegations are that he physically abused one of the children. Is that correct?
Yes, sir.
And that's why he's charged with aggravated child abuse.
Yes, sir.
And that was the oldest child, Christian.
Yes.
And according to your petition, he, while he was intoxicated, threw the iPad against the wall in the Super 8 where they were staying, and he also then grabbed him by the arm, drug him across the bed, and grabbed him by the neck and held him down by his neck.
Yes, sir.
And all of this was related to you by the children.
Yes.
And then when the police arrived, they charged him with aggravated child abuse and aggravated on 2 counts of that. And that's what he's in jail for now.
Yes, sir.
And then while he's been in jail, as I understand, according to your petition, he's attempted to contact or make contact in violation of the bond condition.
Yes, sir. I had to call the jail and have them to block my number.
All right. Mr. O, do you have anything else?
No.
Thank you. You may sit down. Do you have any other witnesses, Mr. O?
No.
Mr. Hassler, if you want, I'm sorry, Mr. Lancaster, if you want to testify about this situation and give your version of the events, come around. You've been placed under oath, so I'm going to remind you of one thing. You have pending criminal charges against you in Humphreys County, and those are serious felony charges. You understand that?
Yes.
You also understand that you do not have to testify about those circumstances of this, what happened that led to you being arrested. If you choose to testify about those events, then the attorney for your wife or former wife can cross-examine you about those questions. In fact, he can ask you questions about that right now. You have the right to decline to answer under the Fifth Amendment of the Constitution. Our Fifth Amendment says that no one has to be forced to give testimony that would implicate them in a criminal activity. So while I'm going to give you an opportunity to testify, I'm reminding you that anything you say today is being recorded. It will be available to be used against you in the prosecution of those felony charges. So you need to decide whether or not you want to testify or say anything about these events. You understand all those rights?
Yes, I do. I have a statement prepared, Your Honor.
All right, you can read your statement.
Your Honor, members of the prosecution in this court, I would first like to apologize for having to read this statement. As much as I would rather speak these words from my heart, I find that doing this way under documentation lacks a certain genuine sincerity. However, due to the critical degree and seriousness of my thoughts, I find like this is the only way to convey the accuracy and depth of the thoughts and emotions in my heart. First, I would like to say that I fully understand this motion, and while the prosecution as well as my wife think that it's needed. However, as I understand, I cannot agree as a majority of this motion is absurdly false and fabricated by the prosecution. I will say with utmost honesty that very few statements in this motion are true and factual. I acutely, and I do mean acutely, remember every moment that occurred that day, and I'm severely struck by the fact this motion exists. This motion is stating and requesting that an ex parte restraining order be granted and amend the current parenting plan set forth by my wife and myself. I'm requesting that this motion be denied due to the fact as no contact order is currently in place for the events in question. To grant this motion would simply be repeating actions that are already in place. I'm currently unable to have any contact with my children under any circumstances until otherwise granted by the courts. Furthermore, when granted, my contact will be ordered supervised until progress is made. On the subject of progress, I'm currently incarcerated, and while being so, I've taken part in several therapy programs to better myself as well as a father, including anger management, conflict resolution, celebrate recovery, co-parenting, mind restructuring, behavioral therapy, financial therapy, and fatherhood training. These numerous therapy sessions have greatly benefited my well-being. I'm also pre-enrolled in outpatient therapy as well as Aikido, a martial art that's centered around spiritual well-being and discipline and centeredness. On a separate note, I would like to request that my wife take similar steps to heal her past as well as I take steps to heal mine. I say this because I want us to learn to work together peacefully as unified co-parents for our two children. In closing, I again ask the courts this motion be denied due to unnecessary repetition, as well as giving me a significant opportunity for my wife and myself to be the loving and productive co-parents my children so intentionally deserve.
Mr. Odle, you have any questions?
Just briefly, Your Honor. So, Mr. Lancaster, you would agree with me that on the May 28th, you were exercising visitation with your children, correct?
Yes.
Okay. And you got extremely intoxicated, didn't you?
I did not get extremely intoxicated, no.
Okay. Were you drinking alcohol?
Yes, I was.
Okay. And police were called to the hotel by management of the hotel. Is that correct?
According to my recollection, yes.
Okay. And they made that phone call because you were drunk, correct?
I do not recall being drunk. As I stated, I remember every single instance that happened that day. Specifically, the allegation of me being passed out by the pool simply did not happen. I will swear under oath that did not happen. I remember all the games we were playing. I remember everything that happened that day.
And you had hidden alcohol from Miss Hassert when she dropped the children for the visit, right?
I do not recall hiding it. And as previously stated, hiding it in the bathroom. I did not hide it in the bathroom. It was just sitting on the counter.
You had it. You knew you weren't supposed to have it when you were visiting the children, correct?
Yes.
So you readily admit that you violated the previous parenting plan. I did.
Yes.
And one of the children got on his iPad and started using it, correct? You recall that?
Yes, I do. Christian had asked me numerous times that day to hook up the Wi-Fi to the iPad. Before I did that, we went down to the pool and we were playing games. He was in the shallow end. I was in the deep end. I would swim under the water and just kind of, get his, touch his legs, a little bit to, kind of playing the shark game. After that, we did leave the pool after having a very good time at the pool, and we came back up to the motel room. At that point in time, Christian asked me again about the Wi-Fi, and due to I've been taking prednisone, which is a steroid medication, and it can cause drastic mood changes. I therefore then I did become angry, and when I actually made contact with Christian, I'm sorry, I apologize. My hand was not choking him. It was in close proximity to his chest and neck, but I was not choking him. Christian was actually speaking to me the whole time.
You threw the iPad and broke it, didn't you?
I tossed the iPad behind me. I do not recall that iPad touching the wall. That had to be pre-existing damage.
And you were afraid that he was contacting his mother because you were drunk.
Actually, no, and I'm glad you brought that up. For some reason, I did not receive any calls from Ms. Hassert. My phone had been dropping calls, and I could show you on the phone itself. My phone has since been stolen, but I did not receive any calls from her. I have never denied Christian from talking to his mother. I've never done that, even in the past, even with alcohol consumption. I've never done that.
You knew they were calling to tell their mother that you were drunk.
No, I did not.
And you got charged with aggravated child abuse.
Yes.
Because of the events of that day, correct?
Yes.
And you've been incarcerated ever since.
I've been incarcerated. Yes. Well, I have not been incarcerated ever since. I was incarcerated in Dixon, and I was able to bond out, and I was incarcerated here in Humphreys County.
Okay. What are you charged with here in Humphreys County?
It was a dispute between a construction customer and myself, and they are attempting to charge me with fraud.
Okay, so that's where you stole some money.
I did not steal money per se, but that is the alleged charge.
Judge, no further questions.
All right. Thank you, sir. You may step back over.
Thank you.
Oh, you have anything else
No, Your Honor.
you wish to be heard in argument?
Just briefly, Judge, that parties were divorced in January of this year. Mr. Lancaster, during a visitation, consumed a large amount of alcohol. He's got serious pending charges for assaulting children, and our position is that there's been a material change of circumstances, and it's in the best interest of the children that the proposed parenting plan be ordered by the court, and that he have no contact with the children moving forward.
Well, this job requires me to consider the best interest. The law requires me to consider the best interest of the children in every decision that I make. The rights of the parties are always subject to and inferior to the children's protection in certain situations. The parental rights of an individual are one of the most sacred rights that we have, and they're not lightly removed. It requires, for a termination of parental rights, of clear and convincing evidence. But the suspension of parental visitation is a matter that the court can consider the best interest of the minor children. Right now, Mr. Lancaster is facing some very serious criminal charges. The two aggravated child abuse charges, and against this court's advice as far as his rights under the Fifth Amendment, he's now testified, and he's given testimony that the state can now use in the prosecution to indicate, along with the testimony of the children, I assume, that he may be guilty of these charges. In any event, there is no question that under the prior decree of divorce, the final decree and parenting plan provided under subsection J, the following special provisions were to apply. Neither party shall consume alcohol or controlled substances other than a prescription immediately prior to or during the residential time of the minor children. Mr. Lancaster has admittedly violated that during the incident that occurred. This plan will be effective when the father moves out of the marital residence and upon the father completing an alcohol and drug program along with a demonstrated 4-month period of sobriety. So before he could even begin visiting under that prior order, he was supposed to have completed an alcohol and drug program along with a demonstrated 4-month period of sobriety. And under these circumstances, the court finds that he's clearly in violation of those provisions of the parenting plan, that the pending criminal charges against him arising from the alleged abuse of the minor children, along with his own testimony today about the circumstances, makes it very clear that right now it is in the best interest of the minor children that the parenting plan proposed by the mother, which suspends the father's visitation, be granted. This suspension is just that, a suspension of the current plan, and it will be up to you after you resolve these criminal charges and you're released from jail. Clearly, you can't have visitation while you're in jail. Once you are resolved, you've resolved these criminal charges and you're released from jail, whenever that may be, then you will have the burden of filing something with the court to try to come back before a judge and demonstrate to the judge, me or one of the others, that you have gotten control of your addiction to alcohol and drugs, and that you are a fit person to have contact with your minor children. Any order that we put down is not permanent in the sense that it can never be altered. It's only permanent in the sense that until there's a material change of circumstances. I clearly find there is a material change of circumstances that occurred since the entry of the final decree and parenting plan in this case, and that Mr. Lancaster has violated the terms of that parenting plan, and basically upon the court finding of that, coupled with the fact that there are pending criminal charges involving the alleged abuse of the minor children, that visitation is not appropriate at this time. So your motion is granted. Thank you.
Thank you.
You'll need to send a copy to Mr. Lancaster at the jail of this order. Thank you.